Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution, this honorable court.
Good afternoon and welcome to yet another virtual oral argument in the First Court of Appeals here in Houston, Texas. We have one case on today's docket, case number 0120000055 American Midstream LLC versus Rainbow Energy Marketing Corporation. Can I have appearances of counsel, please, for the appellant?
Yes, Your Honor. This is Mark Trachtenberg for the appellant, American Midstream.
And for appellee?
Good morning. Good afternoon, Your Honor. This is Alan York on behalf of the appellee Rainbow.
And my understanding is that for principal argument, Mr. Trachtenberg will speak for 12 minutes, reserving 3 minutes for rebuttal. And in the middle of those two, Mr. York will be speaking for 15 minutes.
Correct.
Correct, Your Honor.
All right, then. When you're ready, Mr. Trachtenberg, and when Mr. York has been moved, there he is, you may proceed.
Thank you, Your Honor, and may it please the court. I'm going to focus on two cross-cutting errors that independently require reversal of the lost profits judgment against American Midstream. First, the liability findings rest on the trial court's erroneous interpretation of the Mag 5 contract, and this error is fatal both to their contract and tort claims. Second, the lost profits damages model is egregiously unreliable, does not come close to meeting the reasonable certainty test. Its assumptions are entirely divorced from the facts of this case, and it's based on a high-risk trading strategy that Rainbow never employed, that is hindsight-driven, and that is wholly incompatible with Rainbow's 25-year trading history. And I want to make sure I reserve some time to explain why this model does not support the judgment. But first, turning to the first argument on liability, the trial court's liability findings rest on its improper construction of Section 9.1 of the Mag 5 contract. Now, remember, the idea behind the Mag 5 was that it was a way for the parties to profit off of American Midstream's ability to run daily imbalances between the scheduled gas and the physical deliveries of gas at the Magnolia Transco interconnect. And American Midstream often had imbalances of up to 40 to 60,000 per day that it could make up at the end of the month. But the operational balance agreement, or OBA, with Transco said that if these imbalances exceeded 5% of total nominations and caused operational concerns, then Transco could limit those imbalances. And the Mag 5 allowed Rainbow to use up to 20,000 of this out of balance capacity with corresponding limitations on the usage contained in Section 9.1 if Transco requested or required balancing because of operational concerns or otherwise.
Mr. Trachtenberg, can I ask a question?
Your Honor.
What impact, there's evidence in the record and in that December 7th phone call of Transco's kind of unexpected policing suddenly of the balance. You mentioned it used to be 40 to 60. Your client entered the contract for 20,000 units, and then suddenly this policing starts. What impact, if any, did that policing have on what happened here and why we're here today?
I think it's a large part, Your Honor. I think that there was certainly some changing personnel there. There was changes in the gas flow that impacted Transco, and just Transco was undergoing a merger at the time with ETF that was affecting how vigorously they were policing it. But there's no doubt, and if you look at the context of that conversation in December 2017, which is the basis for their repudiation claim, it's clear that the parties understand that these are the operational constraints that we were operating under, and that Transco was imposing, and the parties were simply trying to work out how to deal with that, how we could accommodate Rainbow within those constraints that triggered Section 9.1. And those constraints, importantly, did trigger 9.1 because Section 9.1 was intended to work together with the OBA that I just mentioned. And getting back to the contractual language of 9.1, with the sentence that's in dispute, it says, with party name substituted, that balancing services are unavailable on any day where either American Midstream or Rainbow is requested or required by Transco to balance receipts and deliveries of gas that are attributable to Rainbow. And as oral argument exhibit 1 demonstrates, the trial court rewrote that sentence so that the limitation only applied if Transco requested or required Rainbow to balance scheduled receipts and deliveries.
Is all Is all we're concerned about excuse number one?
That's correct, Your Honor. We're focusing on that first sentence and the trial court's insertion of the word scheduled in terms before the word receipts and deliveries, which is not included in the unambiguous contractual language. And that's for good reason, because if Transco is having operational concerns about low pressure or high pressure on its pipeline, it's the physical imbalance between the scheduled gas and the receipts and deliveries of actual gas that would be causing the problem. If too many shippers are shorting the pipeline, too much gas is going out, and not enough is coming into Transco, it creates a dangerous low pressure situation. And that's what was happening here. For all but one of the specified breach days, there was a written OFO or critical alert in place asking all shippers in Zone 4 to balance receipts and deliveries of gas, as reflected in
How does that all shippers play into the contract language in 9.1 about attributable to Rainbow? Does Rainbow need to be individualized in the OFOs, or how does that apply? That
So
language attributable to Rainbow.
Right. So Rainbow, the sentence we're focused on in 9.1 could be a request or requirement to American Midstream or Rainbow. And if you look at the OFOs at issue, the way they read is that they apply to all shippers in Zone 4. So if they don't specify a specific shipper, they have the 3 asterisks that applies to all the shippers in Zone 4, which would include Rainbow here. And so, for that reason, we believe that when there were OFOs in place, 9.1 was triggered and there was no contractual breach. Now, for the other days, for all these OFO days and for the few alleged breaches where there wasn't an OFO in place, American Midstream could not have breached the contract for a second reason, because the instant message communications between Rainbow's scheduler and American Midstream schedulers did not constitute a breach. You would have expected, if Rainbow's reading of 9.1 were correct, you would have expected the Rainbow participant to just direct American Midstream to schedule 20,000 MMBTUs the next day. But rather, Rainbow was seeking guidance from American Midstream as to how much it could nominate. And on a handful of days, American Midstream advised Rainbow to nominate some amount less than 20,000. But remember, Section 3 of the MAG 5 imposes the obligation on us to deliver and receive gas only as nominated by Rainbow. They had to make the nomination. And as oral argument exhibit 2 demonstrates, American Midstream confirmed Rainbow's nomination in full all but one time. And over the course of the contract, 207 out of 208 times. So there's no contractual breach here. And
weren't they somewhat discouraging in their conversation as far as being able to handle the full amounts?
They certainly that's the case, but our argument is that's a theory of anticipatory repudiation. That the idea is that we're not going to perform if you do X, we're not going to do Y. But that we don't, as our briefing points out, we don't think that rises to the high level of anticipatory repudiation.
So is
under
it your
Texas law.
position that they would have been allowed the full 20 had they just gone ahead and?
On any day when there wasn't an OFO in place, they could, if they nominated 20,000 and there wasn't anything else that limited them in 9.1, they would have been entitled to their 20,000. I see that I've got about 4.5 minutes left. I do want to make sure I cover damages. I know it's a complex model, but we believe this model utterly fails the reasonable certainty test. Under Texas law, lost profit models typically pass this test if they're based on historical profits or anticipated revenues derived from identifiable contracts, but models based on chancy business opportunities, changing market conditions, or fluctuations or unproven enterprises do not. And we believe Rainbow's model falls into this latter category. Now, it could have built its model by calculating the amount of gas it sought but was unable to obtain on the alleged breach days, and then identifying what cover costs or lost sales were associated with the missing volumes. That would have been consistent with its liability theories and its historical usage of the MAG 5 in daily trading. But that model produced a low number, about 200,000, according to our expert. So they got greedy and they created a model that would generate a $7 million recovery here. Oral argument exhibit 3 hit some of the high points, the assumptions in that model. And I'm going to rely on our briefing to explain them, but I want to make sure I touch on three huge problems with the model. First, the complete disconnect with the facts of this case. Second, the fact that it could only have been adopted with the benefit of hindsight because it would have resulted in massive losses with just slight changes in weather patterns. And third, it relies on key assumptions about Rainbow's ability to transport the gas to Zone 5 that are contradicted by the record.
So
We
with regard to Rainbow's damage model, the $6 million damage model, is there anything in the contract that would make that type of damages foreseeable?
I mean, I don't believe so. They certainly never informed, there's no evidence that they, of any contemporaneous documentation that they ever intended to employ this model. They never told us they intended to use, to use the Mag 5 in this way. And the historical record is to the contrary. They didn't use, looking at their 25-year trading history, when they did use forward sales contracts as they did in the Mag 5, they typically matched them up with forward supply contracts and firm transportation. And again, during their historical usage of the Mag 5 throughout 2015, over 100 times used, most of those nominations were for 5,000 MMBTUs or less. Every single nomination was confirmed. We certainly did not have any reason to foresee that they would use this, and we don't think there's anything in the contract that would have given us
Assume with me for a second that the court disagrees with you and finds that you did breach the contract.
Okay.
But also assume with me that the court agrees with you and finds that the Rainbow model is too speculative. What damages would they be entitled to?
So they have a benefit of the bargain damages award. I'm sorry, an out-of-pocket damages award that they declined to exercise when they elected for benefit of the bargain damages. We think that element is also problematic because of the value received portion of that calculation. So out-of-pocket would require some kind of evidence about what the value of the Mag 5 was. And there is value here as a transportation contract. We're talking a lot about the balancing services used, but it also allowed them to move 25,000 of firm transportation using the pipeline. They never valued that. So I guess in that situation, Your Honor, it probably makes sense to remand and look, and we can look at that. We think the benefit, the out-of-pocket measure fails as a matter of law, but at the very minimum, we could go back to the trial court and look at that. But we think the benefit of the bargain measure certainly fails under the lost profits.
So it's your contention that the $991,000 found by the trial court is not supported by sufficient evidence?
That's correct. We didn't brief that. We have a footnote that talks about, we point out one error in the calculation with respect to the net revenue deduction that we think they misapplied. We didn't brief it because they didn't elect it, except for the point that we made as part of our larger point with that there's no evidence of value received at all, which impacts both of their requested measures. Does that make sense? Well, you look puzzled, so I want to make sure I get the.
Well, there's a lot about this case that is puzzling. So
yes, I understand.
A lot of moving parts.
I see that I'm running low on time. I would refer the court to the oral argument exhibit 4, which really illustrates how this model diverges from reality. And I'll rely on the briefing to elaborate on that point. But we believe we ask the court to reverse and render the judgment in favor of Rainbow and render judgment for us in our counterclaim.
Thank you very much, Mr. Trachtenberg. Mr. York, you have 15 minutes.
Thank you, Your Honor. May it please the court. Again, my name is Alan York, appearing on behalf of the appellee, in this case, Rainbow Energy Marketing. Let me start off with a point of agreement with AMID, and that is the 2 points that will be covered in oral argument today, which will hopefully be helpful to the court because these are the 2 major points that opposing counsel addressed, are the same 2 points that we will address in our time before the court. First, the propriety of the contractual interpretation that was performed by Judge Garrison as the trier of fact and trier of law in the court below. And secondly, the soundness of Rainbow's damage model. With regard to contract construction, the starting point is obviously, and I think both parties agree on this, Barrow-Shaver, the Texas Supreme Court precedent. The parties obviously see this precedent in different ways. AMID has argued that the district court went outside of the confines of Barrow-Shaver in interpreting specifically section 9.1 of the Mag 5. But in fact, Barrow-Shaver's wording in and of itself supports the trial court's actions in every way. As a quick reminder, Barrow-Shaver factually involved a situation in which Barrow-Shaver was alleging that an otherwise unambiguous consent to assignment clause had implied within it a necessity for reasonableness of withholding of that consent. And in considering that argument, the Supreme Court said that it was not appropriate to consider industry, trade, and custom in order to imply a term that otherwise did not exist in the unambiguous terms of the contract. But the Barrow-Shaver Court went further than that to specifically talk to the appropriate use of industry, custom, and trade as well. And specifically at page 486 of their opinion, the court said—
Let's talk about this specific contract because it's the one that's before the court right now. What is the substantive difference between in section 9.1 of requiring the party to balance receipts and deliveries, and how the trial court recited it as balance between Rainbow's scheduled receipts and scheduled deliveries? What meaning do we attach to the word scheduled?
The reason that the scheduled deliveries and receipts is important, Your Honor, is because as AMIT has already agreed, the MAG 5, because it relies specifically on the OBA that AMIT had with Transco, actually we have to look to the OBA in order to understand what receipts and deliveries means. MAG 5, when you look at the contract itself, does not define receipts and deliveries. But because it's reliant upon the underlying OBA, it's important to look to the OBA, as the court did, to define what receipts and deliveries actually mean. And the OBA at paragraph 2 specifies that the parties intend that the quantity of gas actually delivered and received each day at each location will equal the scheduled quantities for that location. All scheduled quantities at each location will be deemed to have been received and or delivered under the applicable shipper agreements. In other words, the scheduled quantities and deliveries and receipts is not a concept that the trial court came up with on its own. It came up with that, it used that concept based specifically on the wording of the OBA, which defines deliveries and receipts within this context. And specifically, that definition means that because deliveries and receipts are deemed to have been received, that in this particular situation, once Rainbow nominated a quantity of gas and that nomination was confirmed, it was deemed that that was received, delivered and received. So that's also evident by the MAG 5, by the fact that the principal point of delivery and receipt under the MAG 5 is the same point, and that's the Transco interconnect.
So
This was
so it's not talking about a physical flow imbalance. It's talking about a schedule flow imbalance.
That is exactly correct, Justice Hightower. What the district court did was look to the OBA, which again defines these delivery and receipts. And returning again to Barrow-Shaver, when the parties use imprecise terms in an agreement, especially in an oil and gas agreement, the Supreme Court has said that it's perfectly appropriate to look to industry, custom, and trade to define those imprecise terms in order to interpret an unambiguous contract. So the parties agree here that this is an unambiguous contract. The only point of diversion is that the district court did exactly what AMIT continues to argue it should do on appeal, which is consult the OBA. But when you consult the OBA, those deliveries and receipts are defined as being deemed as having been delivered or received.
Well,
So-
I had a question. I wanted to make sure I'm following your theory here. In your interpretation, this would only be triggered if the OBA was no longer in place, though, right?
That
So
is-
we're looking to a document to give us meaning, but then somehow this would only apply if that document wasn't there.
That's the net effect of this, Justice Ferris, is that realistically, Rainbow, under the terms of the MAG 5, could not be out of balance unless the OBA was suspended or if somehow it was inapplicable. But because of the terms of the FERC tariff that was in place by for the Transco interconnect, and the fact that that incorporates the OBA, and as AMIT has conceded again in oral argument, the fact that the MAG 5 is really derivative of this imbalance that is allowed under the OBA between AMIT and Transco, this deeming language is vitally important in order to determine when and only when AMIT is entitled to use one of the excuses to not satisfy what was bargained for, which is a firm balancing agreement, meaning that that Rainbow should have had the ability on a regular and consistent basis to nominate up to 20,000 MMBTU per day under this contract. Now that's important for another reason. And it's a reason that applies both to the contract interpretation, but also to the damages argument. And that is going back to what the very basis of this contract was. Now, the AMIT has argued that in response to Justice Kelly's questions, that there was no documentation that it was foreseeable that this contract would have been used, for example, to make future sales contracts, et cetera. And yet AMID's actual trial testimony was that it was absolutely foreseeable that Rainbow would use the MAG-5 to enter into forward sales contracts. That's a very important point because that is the basis of this contract. Rainbow's business was to generally—
Where in the record is that testimony?
Actually, Your Honor, I'm having that looked up right now, and I will provide that I will provide that specific site in just a moment. I apologize, I don't have it readily here in front of me, but I know it's cited in our brief, but I will provide it in just a moment. But again, this contract was intended so that Rainbow had the opportunity during the summer months to enter into forward sales contracts so that the contracts would be in place, that it would be providing gas to its customers during the winter strip, which was generally November of one year into March of the next year. The MAG-5 was important for providing reliability of the ability to provide that gas. So all of these individualized discussions of individual days and things like that that AMID is relying on don't go to the underlying purpose of the contract. As is reflected in the record, Rainbow's attempt to use this MAG-5 on multiple occasions was to test its reliability, because in having a reliable contract such as this, it could then with comfort and confidence enter into these forward sales contracts.
So this is a very sophisticated arbitrage plan here. Had Rainbow engaged in this particular type of arbitrage in the past?
Yes, Your Honor. So I will say this. There is evidence in the record that Rainbow had used, for example, the MAG-1 transportation contract to enter into forward sales contracts and then use that MAG-1 in order to ultimately supply those contracts during the winter strip. And so the basis of the damages model is basically saying, okay, if we had the capability to reliably enter into these forward sales contracts and had done so, then this is what our net profits would have been. And it's also important when we reach the damage model to address—
But the MAG-1 covers a different subject matter than the MAG-5.
That is correct. That is correct.
So,
MAG-1 is clearly a transportation.
But I guess the precise question is, did Rainbow ever have a month of profitability of using the capabilities conferred under the MAG-5 to make money?
Yes. And that's actually reflected in the actual damages model. And if the court will look to that specific damage model, there are two columns. One is expected profits under the MAG-5, and one is actual profits under the MAG-5. And so the actual profits column established that, in fact, Rainbow, when it did use the MAG-5 for its intended purposes, was able to make profits. One of the issues of reliability of the damages model that I would be remiss if I didn't point out is that this is not a pie in the sky damages model as AMID has attempted to paint it. There are several, for example, undisputed, objectively verifiable bases for the damage model. For example, the damage model only seeks damages for the periods of January through March 2016, November 2016 through March 2017, and November 2017 through March 2018. In other words, only for these winter strip time periods that the MAG-5 would have actually been used. Now, this was a firm balancing agreement, which means that despite the fact that it would only be used during those months, Rainbow was paying on a monthly basis every month, whether it used the MAG-5 or not. So to the tune of over $1 million a year, Rainbow was paying for what it had bargained for, which was a firm balancing agreement. But within the damage model itself, for example, the revenue stream that is reflected is based upon index terms and contract terms under the MAG-1, and there's no objection.
Does the model take into account, though, certain contingent risks? I mean, just in the past 6 months alone, I mean, this year we've had, our Texas freeze, where we certainly had interruption of gases. We had the Colonial Pipeline being taken down by hackers. I mean, it seems to me that Rainbow is asking for a risk-free payment of its arbitrage plan without accounting or any discounting for potential contingent liabilities, contingent risks.
And Justice Kelly, that's certainly what AMID would have the court believe. But if you actually look at the damage model itself, the model itself debunks that theory. And the reason that it does is because this is a realistic model. It doesn't simply show that we would have profited on every transaction that we made. on several months, on several days. The model actually reflects that we would have lost money in using the Mag 5. And so it is not, again, it's not a pie in the sky model. It's reflective of actual and real world experiences. And again, going through the revenue, the expense of transport, the expense of demand charges, all of the data points that are necessary to make the model are absolutely uncontested. The only thing that is contested realistically from AMID is whether Rainbow would have actually engaged in this model. Now, Judge Garrison had the opportunity to hear the witnesses at trial on this issue and determine on the credibility of the witnesses that Rainbow would have done exactly as they testified that they would have done, that they would have used this model in the way that used the Mag 5 in the way that the model reflects, and that as a result of that use would have had times that they would have lost money and would have had times that they profited. But over the 3 periods that we've talked about, the January through March of 2016 and the 2 additional winter strips, offset by the demand charges they would have had to have paid throughout the time period, Rainbow ultimately would have profited by the $6.1 million in change that the court found to be the actual damages in this case.
And are we talking about customers that were already in existence? Is that the damage model? These were already your customers?
Yes, Justice Hightower, that is correct. These are customers that we had in place. And by the way, again, I return to the fact that none of these revenue streams, none of these issues of revenue that were included in the damage model were contested in any way by AMID. The only thing they contested was whether we would have actually acted the way that we did as reflected in the model. And again, that becomes a credibility issue for the testimony of the witnesses that is left to the finder of fact, in this case, Judge Garrison. She heard that testimony. She determined that this is exactly how Rainbow would have acted, making the model both verifiable and sufficiently certain so that it does not violate any speculative rules that are set out for future damage models.
Is there anything that Rainbow could have done to mitigate its damages?
Actually, Your Honor, the record is replete with examples of us actually mitigating our damages. The fact that we continued to use, even when we were deprived of the firm balancing that was the subject of the contract, we continued to use the Mag 5 to the extent that we could. And all of those profits that we actually made under the Mag 5 are offset against what the anticipated profits were. So there's not only evidence that we could have mitigated damages, there's affirmative evidence that we did mitigate our damages. So again, returning to the reliability of the damage model, Judge Garrison heard the evidence. Judge Garrison considered the model, and more importantly, considered the credibility of the witnesses as to how this Mag 5 would have been used in real world circumstances, and determined that that testimony was credible. By the way, before my time expires, Justice Kelly, the testimony regarding the foreseeability of the Mag 5 for forward contracts can be found at volume 8 of the record in page 205. And I believe it is also included at volume 5 of the reporter's record at page 11. With that, I see my time has expired. We ask that the court affirm the district court's judgment.
Let me ask one last quick question, because the briefing was conflicting on this. Did the OFOs apply to Midstream as an OBA party?
No. And your Justice Hightower.
That is contested, isn't it?
Well, it is not. The OFOs do not apply to AMID as an OBA party. That is clear if you look at the OFOs. And in fact, the record is replete with testimony with AMID conceding that the OFOs did not apply to them. But more importantly, AMID's corporate representative consistently also testified that we believe in part to the derivative nature of the Mag 5, the OFOs were not applicable in any way to bar the use of the Mag 5, even when they were in place.
Okay, thank you.
Thank you, Mr. York. And Mr. Trachtenberg, you may proceed.
Thank you, Your Honor. I want to start with your question, Your Honor, Justice Kelly, about the arbitrage issue and the hindsight aspect of this. And it's really important that the court understands this. Because the question is not whether they could run this model at the time of trial and know that it would show millions of lost profits, even if there had some months where they would have suffered losses. But the question is whether they would have implemented the strategy in January 2016 without knowing what the weather patterns would be. And if they are what they profess to be, which is a risk-averse company, there's no way they could have, because an early cold front in a winter month would cost them millions, because a Mag 5 didn't allow them limited amount of gas they could pull in the early part of a month. And so they would be forced into the daily market in the event of a cold front there. If there was a late cold front, they could face significant exposure, because that's when they have to backfill the Mag 5, and if they've taken gas out, put gas back in and buy that gas at the daily market. I know we go into this in great detail in our brief, but it's really important to understand that just a slight shift in the weather patterns and when the cold fronts came in different months would have exposed them to millions and millions of dollars of losses. And so, yes, they can say, well, there were a few months we lost in our model, but the point is they never would have entered this model in the first place without the hindsight of knowing what the prices were and what the weather patterns were at the time. I think it's really important to go back to the point that this is not how they used the Mag 5 historically, or the Mag 1 for that matter. I would point the court to Matt Steinberg's testimony. He is the person on their side that conceived of this contract. And I would point to his testimony at RR3 at 261, 262. On a phone call on this December 7th phone call before they developed this litigation position, their executive, Acer, said the purpose of the Mag 5 was to catch the 4 or 5 day snap and replace it when the cold snap is over. That's at PX 12 at 12. What they were trying to do is find those few days where the prices were high and use the arbitrage that way, as opposed to locking in forward sales prices months and months and months in advance. And whenever they did have forward contracts, no doubt they did with the Mag 1, but they always paired them with forward supply contracts as well. As for Barrow, Barrow allows you to use industry customer language when there's an unambiguous, when there's an industry term that people don't understand or having trouble understanding, you can shed light on a term that way. But here they're talking about inserting the word scheduled into an unambiguous contract. That's not industry custom. That's not what Barrow teaches. Barrow teaches the opposite of that point. And finally, I think it's a really important point about the December 12th phone call. We haven't had a chance to talk about their continued performance after the alleged repudiation in December 7th, 2019 or 17. I'm sorry. Number one, there was no repudiation. That doesn't rise to the level of repudiation because we had a contractual excuse. And number two, they continued performing for 6 weeks after that, and so they don't get to terminate the contract, and their damages at a very minimum should be cut off there. I'm sorry. See, I'm running out of time, and I appreciate the court's giving us the opportunity to argue today.
Thank you very much, Mr. Trachtenberg. Case number 0120000055 American Midstream versus Rainbow Energy is submitted, and the first Court of Appeals will